In this video I want to just take a brief look at what happens on closing day when the sale is supposed to close on a particular day, the property sale, and doesn't complete. The bottom line is, where there's a default on the part of the purchaser in failing to complete the sale on closing day, the purchaser is liable to pay interest at the contract rate, and the vendor will be entitled to any rents and profits up to the actual date of closing. If the vendor has been in default and has not been ready, willing and able to complete on closing day, he must give the purchaser at least 5 working days notice of a new proposed closing date. General Condition 36 of the Law Society contract for the sale of property in Ireland has provision for completion notices. A completion notice is a 28-day notice that either the vendor or the purchaser can serve on the other party. So the vendor may serve a 28-day notice by post, personal delivery or fax, and the vendor may then, once he serves the 28-day notice, which makes time of the essence, in other words, it imposes a cut-off point in the contract. It can't go on indefinitely. So the 28-day notice, the formal 28-day notice, makes time of the essence. And after that then the vendor may sue for specific performance and damages, may forfeit the deposit and resell the property and rescind the contract. The purchaser, on the other hand, may sue for specific performance and damages and can ask the vendor to return the deposit. In relation then to the forfeiture of deposit and resale, General Condition 37 makes provision for this, and if the resale takes place within 1 year of the original closing date, the deficiency, if any, arising on the resale, along with costs and expenses, shall be made good by the purchaser to the vendor. So to be clear, the vendor can go ahead and sell the property within a year, and any deficiency that's arising then, he can go after the first purchaser and look to make up the deficiency and any costs or expenses. Damages for default then are provided for in General Condition 38. It provides damages for a purchaser where the said purchasers obtain an order for specific performance by the vendor of the contract. In other words, the purchaser serves a 28-day notice, then obtains an order for specific performance, and can also then sue for damages, because the purchaser can obviously have various costs and consequences arising from the failure by the vendor to hand over vacant possession on the closing day and complete the sale. So that particular General Condition 38 provides for damages for the purchaser where the vendor has failed to show title to the property in accordance with the contract, and that's a separate remedy for the purchaser. So that's basically what happens when a contract of sale for the sale of property is supposed to complete on a particular day. Then 28-day notice is generally the default position, and after serving a 28-day notice, time becomes of the essence. In other words, there is a cut-off point imposed, and after that then, as I say, either party, either the purchaser or the vendor, have different remedies. The purchaser can sue for specific performance and damages, and the vendor can sue for specific performance and damages and can forfeit the deposit and resell the property and get the deficiency from the original purchaser. So I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thanks for watching.